So good morning, and thank you for joining Guardianship versus Conservatorship. Which one do I need? We are very lucky to have with us Christopher Hanks, an estate lawyer who will walk us through what these terms mean and how they play out in Virginia. So Christopher, thank you so much for being here this morning.
Thank you so much for having me. I'm really looking forward to discussing this a field of law that I think doesn't get a lot of attention, but is only going to become more and more important and impactful as the baby boomer generation ages. So I really appreciate you hosting this, Megan. So this talk, I really want to go over what this field of law covers, who needs a guardianship and conservatorship legally, what the court process is like for appointment, relative costs, and then a very broad overview of the duties of a guardian and the difficulties inherent in it, and the duties of a conservator and the difficulties inherent in it. And before we really get started, I want to make sure it's clear that this covers Virginia law only. Aspects of this will be applicable to the District of Columbia or Maryland or any other state, but I specifically here am talking about Virginia law and cite Virginia code in the talk. So being a guardian or a conservator under Virginia law, it's defined as a legal status in which a court appoints a person to manage the financial and personal affairs of a minor or an incapacitated person. With the work that I do, this is much more likely to happen with an incapacitated person, either someone who is disabled or someone who is due to age, either unable to vocalize their desires or unable to sort of articulate them, or due to dementia or some other problem is unable to sort of make that happen. And so the court steps in and nominates somebody to make all of the financial and personal decisions for that person. The concept of incapacity is statutorily defined, and this is a lot of word salad. But really what it comes down to is that if the court finds that the person is incapable of taking information in or incapable of expressing their own desires sufficiently, such that they can't meet the basic requirements of speaking to a doctor or advocating for their own position, or they can't manage their financial affairs, they can't pay their bills, they can't manage their property, they can't make decisions. This is what the court terms as incapacity. Now, I can say this word and this phrase is probably, if this issue is going to be litigated in a court, which is rare but does happen, this is going to be the concern. And it's interesting to note, if you look at this code section, there's a specific sentence in there that says making bad decisions is not incapacitated. If your parent is buying a new Camaro every year and they really can't afford, or making poor decisions doesn't necessarily mean incapacity, unless you can say it's because of this diagnosis of dementia or a mental condition that they have. But the court really, especially for finances, will not step in to stop you from making poor financial decisions. They will step in if you're sort of unable to make your own decisions. So I also want to, under Virginia law, it's interesting to note that these are two different roles, conservator and guardian. You can have someone who only needs a conservator. You can have someone who only needs a guardian, although that's less rare. Really what the guardian has control over all medical decisions. So they decide what medical treatments, they decide where the person lives. They decide if the person needs caretakers, who those caretakers are. The conservator has control over all of the financial decisions. I'm personally acting as conservator for a number of people who have different guardians. The guardian and I work together on this case, and that can be helpful for a number of reasons. The guardian in these cases, the guardian knows the ward very well, knows the incapacitated person very well, has a very good idea of what they would want and would not want, but may not have the expertise or really the time to take care of all the finances. And so I step in and I take care of all the finances. I make sure all the bills are paid. I make sure that the house is sold, that the money is invested prudently, and it works out very well. So there is a lot of flexibility in how this is done to make sure that it not only works for the incapacitated person, but that it works for the caretakers as well. Now, these are options, what are called options of last resort. Courts take these petitions very seriously. If you look at the order for one of these, the court order that's put into one of these, the court is taking away a person's rights. They are saying that even if this person says, I don't want to live in this home, or I don't want this care, I don't want caretakers. The court is taking away this person's right to even have that, have that take effect. They're taking away a person's right. They also in the petition could take away a person's right to vote, a person's right to own firearms, a person's right to drive. It's a very serious petition, and so when you file a petition for conservatorship or guardianship, you specifically have to say this person does not have an advanced healthcare directive, and this person does not have a power of attorney documents. Because if either of those documents exist, the court will use those. That's why these documents, when you talk to an estate planning attorney, which is something that I also do, these documents are so important because an advanced healthcare directive allows you to say, this is the person I want to be my guardian. This is what I want them to do. I do want comfort care. I want an artificial feeding tube. I don't want one. I want to, if my organs after my death, if my organs can be used, I want them to be used, or I don't. I want to be buried whole. You get to make all of these decisions in advance. And then really the person that you nominate as your guardian in those documents has a legal duty to abide by those wishes. It also, just as a functional matter, is something that means a lot to the guardian because they don't have to guess. They don't have to wonder if you would not want the feeding tube because you've already made it clear. And that sort of relieves them of the burden of having to make that decision for you. Similarly, with a durable power of attorney, which the word durable is a term of art, but really what it means is that the document itself does not take any effect until you are deemed to be incapacitated by a doctor. Like a doctor has to sign an affidavit that said this person can't make their own financial decisions. You can say what you want to happen. If it's very important to you that the home stay in the family and it not be sold, you put that into the power of attorney document. You say that this person has the power to make margin calls on stocks, or they don't. You make all these decisions and you decide who will be your conservator beforehand. These are relatively easy documents, especially the Advanced Healthcare Directive. If you Google Virginia Advanced Healthcare Directive, there's a document from the Virginia State Bar that has everything that you need that you can use. This is free. You take it to your doctor, you talk it over with your doctor, you get it signed. A durable power of attorney is a little bit more complicated, but it kind of should be because it has to cover a lot more instances. I would highly recommend that you talk to an attorney about either of these, because if there's either of these documents, the court will not hear any petitions for conservatorship or guardianship. The court will dismiss it and say, go deal with it. You've got what you need. So if we are into the court appointment, I wanted to give a very brief overview of exactly what that process looks like. Let's say that we are in Alexandria City Court, what that would look like here. This will take 5 weeks minimum, and that's literally if everything goes right and the sun shines on you. That's the soonest. 6 to 7 weeks is probably more realistic. There's a lot of material you need to gather, a lot of information that needs to be in the petition statutorily, and it also needs to include a medical evaluation by a doctor or nurse practitioner. That can take time depending on where the person is. So I would budget out at least 6 to 7 weeks for this. I would also budget out about $6,500 total for everything, and I'll go more into that. So everything gets together, the attorney files the petition in the court. The court then appoints someone called a guardian ad litem. These are attorneys in the area who have taken specific training and are known to the court to understand these issues. The guardian ad litem is an attorney for the court. They are the court's attorney, and the court essentially tells them, here's the petition, talk to this attorney, here's everybody who is involved, and go talk to everybody. Go meet with this person. There's a statutorily commanded, the person has to go to the person who's the subject of the complaint in the hospital, has to go there personally and serve them with a specific set of papers to ensure that this person knows this is what's happening, this is what it means, you are entitled to an attorney, you are entitled to be here, you are entitled to object. Like I said before, the courts take this very, very seriously. So the guardian ad litem ensures that the person who is the subject of the petition knows about it, that they understand it. They talk to the person who is submitting the petition. They talk to the other attorney. They talk to all of the family members. that they're looking for, does everybody agree that this person is incapacitated? Does everybody agree that the person who's asking to be the conservator or guardian is a suitable person to do it? And that is why that is statutorily from the time you file a petition, the soonest you could have a hearing is 1 month, because the guardian ad litem needs time to talk to everybody, to submit the report. The judge needs time to read it. So that's why I always put 5 weeks at a minimum. And the approximate cost for everything is about $6,500. Now, generally to file the petition, to get all the information together, to serve it, to go to the hearing, I generally quote about $4,500 for the attorney. And then you are also responsible for paying the guardian ad litem for their time. And that is about $2,000, give or take. It could be a little bit more depending on how many people they have to talk to, how much work they have to do. So if someone is indigent, if the person that is the subject of the petition has no money, there are statutory ways for the guardian ad litem to get paid. They get paid a very small amount, but they can still get paid. I take those cases a lot. Every attorney who does guardian ad litem work knows that there is just a need, and so you take those cases anyway. So I don't want to stop anybody from doing this just because the person that they're talking that they need guardianship for doesn't have the money or something like that. But that's the approximate cost that I quote to people. But obviously, talk to an attorney and see what your options are. Another important note is that Virginia law requires that every direct parents, or sort of, I always say the immediate family of the person, parents, siblings, children, spouses, everybody must be notified of the action and the hearing date. They will also be talked to by the guardian ad litem, but you have to specifically serve them and make sure that they know about it to give everybody a chance to object if they want to. If they want to say, the person who's asking to be a conservator is not someone I think should do it, or et cetera. So when I do this for people, it tends to be a little bit of a not a shock, but it can give some of them pause. I know that there's a lot of politics in families. So-and-so's not talking to dad. There's not much that can be done about that. If you don't have a good relationship with your child, you still have to serve them. They may not pay any attention to it or do anything, but you have to serve them, and the guardian ad litem has to try to reach out to them. There are always instances when you reach out to somebody and you're trying to do a guardian ad litem report and you can't reach them, and you specifically note that in your report that you tried and you were just unable to talk to them. But they will be notified of this before the action goes before the court. And if for some reason, let's say a year after the court approves your thing, if a family member can say that they were never notified of this and they wish to object, the whole thing goes back to court and we start over again. So I highly recommend that no matter what is going on, that you know that the rest of the family is going to know about this, as they should. So that was a brief, broad overview, but if everything goes right, everybody agrees, after you are appointed, you will go to a court on a Friday. The judge will look at your petition. They will look at the proposed order that your attorney's prepared, and they will sign it. You've got your court order. You then head to the probate clerk office in that county, and it's in the exact same courtroom, and you go through a process that's called qualification. Qualification is where you take your oath of office. If the judge has required you to have a surety bond, which is sort of an insurance policy that covers the estate or of the person, you'll submit proof of that. You will literally raise your right hand and take an oath. You will then get documents from the clerk that are stamped, that have an embossed stamp on them, that are your qualification, which means not only is there a court order doing this, but the clerk has signed off that everything that they need to do in order to take this office has been done. And they have the statutory authority to act on this person. And those documents can become very important, because when you go to a bank or when you go to a hospital or to a nursing home, they're going to need the original copies of those documents. I always tell people that you can file away your conservatorship qualification. Just keep it in a file somewhere where you know where it is, because you're going to be dealing with banks and financial institutions, and there's rarely a time when you're going to get a hold of a bank at 2 o'clock in the morning. Your guardianship stuff, you need to keep those sort of I would say on you, but somewhere where you know exactly where they are and they can be accessed very quickly, because there may be a time when someone is in a hospital at 2 a.m. and the hospital will not allow you to make decisions because they don't have your guardianship qualification. So as we said before, guardianship, conservatorship, 2 different offices, each have their own sort of requirements and each have their own difficulties. So we're going to go over being a guardian here. I'm not being over dramatic when I say, if there is a problem, you will be called. If you have a parent who who checks themselves out of a nursing home, which can happen in some instances because you get into false imprisonment, someone really wants to leave and the person's out on the streets, they call you and they say, what are we going to do? And you got to figure it out. If that happens to you, call the police. Because if it's bad enough that the person has a guardian and they're out on the streets, I think that's an emergency, and the police should be notified and should be looking for them. The court wants you to have enough contact to know the person's wishes if they can't express them. If it's someone that you have never met, which I have acted in that role before, you talk to family, you look at their religious persuasion. If they're Catholic, what do the Catholics say, et cetera, and try to do the best you can. But the court will be very happy if you can say, I've talked to this person about what they want. They don't want to go to a nursing home, or they do want artificial feeding, any of those kind of issues. And then you have to file a report, which is about a 7-page report with the county or city Department of Social Services. You have to do that. It's not that it's a difficult form. It just ask different questions to make sure that you are in contact with the person, that you're staying on top of it, you know what their needs are, you know what their medical status is currently, et cetera. Guardianship is difficult. Guardianship is I always say you're taking on a responsibility. That's how you should look at it. Not you're getting power over somebody. You're taking on a responsibility, and at end of life, it can be very difficult. I imagine that you are for a beloved uncle or a parent, and the hospital is saying, do you want to sign a do not resuscitate order? Do you want to make that decision? You can do it. And it's a lot easier if the person's wishes are laid out in an advanced healthcare directive, so you know what it is. But if you don't, you have to make the decision about what's best. There are times when the only home that they can afford, the only assisted skilled nursing facility that they can afford is not the one that they like, and they're not happy there. But it's sort of all they can. Can you place them there and not let them leave? So this emotionally can be a very difficult office. I always tell everybody I know that is a guardian for a loved one, you need to find a therapist or counselor or somebody that you can talk to, because you're going to be faced here with things that you're not prepared for, and nobody ever should be. But you will be there. So I highly recommend you have someone you can talk to who can help you through this emotionally. Now, if we're being a conservator, you're dealing with money. This is covered by, obviously, there's the Virginia Annotated Code. Your duties once you're a conservator are to take all of the person's assets. They've got bank accounts, they've got CDs, they've got any, to say IRAs or anything like that, to try to marshal all of it into one account. And you're going to start what's called a conservatorship account. And a conservatorship account is different because it is a bank account that is in someone's name. It is in your parents' name, but you are the only person who could take any action in it. It's in John Q. Ward's name, but if John Q. Ward came in and said, I want to sign a check here, the bank would not let him. You're the only person who can do it, which is what makes it interesting. I always tell people, put it all into one account. It's called marshaling assets. Put everything into one account that you control. So do everything you can to sort of close down other accounts, et cetera. Because then for the bookkeeping portion of it, it becomes much simpler. Statutorily, you cannot hold this role if you're a convicted felon. There's nothing statutorily saying that someone who has gone through a bankruptcy cannot hold this role. But if you need to get a surety bond, which again is just an insurance policy that covers all of the estate's assets. So if you were to take all of the money and flee to Mexico, that the ward could be made whole again. If you've had a bankruptcy in the past, this can be a problem for getting a surety bond. So the first role of being a conservator, right after you're done, you have to build what's called an inventory. And this literally is a sheet of paper that you file with the Commissioner of Accounts. Commissioner of Accounts is an office of the court that oversees conservatorships. That literally puts, this is every single thing that the person owned within reason. on the day I was appointed. So you get bank statements for the person's bank accounts, and literally go to the line of the day you were appointed, and that's the starting date for all the money. You know, I don't want to see, when I say every single thing the person owns, you know, houses are full of stuff. You know, you can put their furniture as one line item, their clothing as one line item. It doesn't need to be that granular in detail, but really what the Commissioner of Accounts does is once they look over it and once they approve it, that's your starting point for your accounting. So you have to go purchase by purchase by purchase to not detail, but be able to show, not even be able to show, be able to show if asked, that every dollar spent was for that person's well-being. So if when you submit your accounting, you submit all the bank statements, you submit the forms, you submit a list of all the transactions. If there's 15 Amazon purchases, there's nothing wrong with buying on Amazon, but what the Commissioner of Accounts most likely will do is say, can we see these receipts for all this Amazon stuff, to make sure that it was something for the ward, that you weren't buying things on your Amazon or you weren't paying your own credit card bills. There are instances where you can pay your credit card bills, but you better be able to show that it was to reimburse yourself for expenses you took on the person's behalf. So you're audited every single year. You know, the difficulties in this are somewhat similar to a guardian, but less. You know, you have complete control of the finance. Can you tell your father that he can't buy the new car that he wants because he can't afford it? That can be difficult. That can go into a lot of animosity. Anytime you can, when you're in one of these things, and I know it goes against the grain of what people want to do, get yourself a independent conservatorship. This is akin to an executor of a will. When I have clients do a will, they get to choose who the executor is. I always advise them to choose someone who's not in the family. It costs a little bit more because if you choose someone outside the family, they can get paid for their services. But I would say the best possible thing that can happen is that all of the family, after you pass, all of the family gets together for Thanksgiving and they say, gee, that attorney is a jerk. What a jerk that attorney is. But they're all together. Whereas if the oldest sibling is the executor on the estate, there's animosity, people aren't getting together. I've seen it. Every single elder care attorney can tell you horror stories for how this went. And also, I act as a conservatorship for a lot of people. I have bookkeeping in place. I have relationships with banks in place. It is very easy for me to marshal assets. I know exactly what the Commissioner of Accounts wants, so I'm not scrambling at the last minute trying to get things together. It can make your life much easier. And the other thing that needs to be put here too is, if you know that your parents need help and you just want to be the son or the daughter, that's okay. There are people like me who act as a guardian, act as a conservator. There are people out there who can do it. If you don't want to do it, that's all right. It's okay just to be a child. In some ways, that's going to be a lot easier. Don't beat yourself up that you have some responsibility to act in this very, very difficult role if you don't want to. You know, as a final note, I just want to say these are, you'll hear this word a lot. Both roles are fiduciary roles. What that means is you've taken on a legal responsibility to care for this person. If you act as guardian for someone and you don't follow up with them and you don't take care of them, you could be subject to massive civil liability. You're taking on this responsibility to act in their best interests. So it shouldn't be taken lightly. It's not taken lightly by the courts. It shouldn't be taken lightly by you either. So lastly, I just want to go over, there is the process of amendment and revocation. I always tell people this is not California. We're not in a Britney Spears situation. I don't want to say it's easy, but there are very clear and very bright methods in place for amending or revoking a guardianship or conservatorship order. Because again, courts don't like these. They know that they're taking away rights. Courts don't like to do that. And so if they can't find a reason to give someone back their rights, they give them the right to amend a vote. I am asking the court right now to give a ward of mine his right to vote back again, because now that I've worked with him for a while, I know that he can make a clear judgment here, and he should, and I have no doubt that the court will grant it. This is covered under, there's a specific statute for it. The very interesting thing to note is that these orders are subject to court review at any time. It can be challenged by any person. It doesn't need to be a close family member. It doesn't need to be the ward. any person can file a petition in court and say, I don't think this conservatorship or guardianship should continue. The court reappoints the guardian ad litem. The guardian ad litem looks at it again, makes a decision, makes a court. The standard here is what is in the best interest of the incapacitated person. So yeah, everybody heard the horror stories about California. Britney Spears had no legal avenue to challenge her conservatorship or guardianship because she didn't have the right to an attorney. That's not the way it works in Virginia. These are serious matters, and they can be amended or revoked if the court thinks it's in the person's best interest. So just in conclusion, I just want to say anything, reach out to me, reach out to another attorney, reach out to an elder care attorneys. There is the Virginia Academy of Elder Law Attorneys, VAELA. They have a directory on their website. I'm also a part of that. Really good organization who can help you find attorneys who do this, who do a lot of this work and know what I've given you is a 30,000 foot overview. There's a lot of small minutia in there that they deal with all the time. I am also available. My contact information is here. My phone number, my email, please reach out. All consultations are free. We will determine what is the best course, but I'm also around to talk. And I really appreciate your time. And I hope that I have helped you in this, helped clarify what is best for you and your family.
Christopher, thank you so much. This has been full of information and definitely an area that can be very murky and hard to understand. So I appreciate you taking the time to explain it to us and give us resources to look further into this if this comes to something that our family has to look into. So thank you so much.
Thank you again.